starting. All attendees are in listen-only mode.
Thank you for joining us today. My name is Dennis Blatchford and I am your moderator for today's webinar. My name is Dennis Blatchford and I am your moderator for webinar number 4, Pension Law. I'm the Pension and Benefit Advocate for the Health Sciences Association of BC. Today's session will introduce participants to pension benefits and tax laws that shape pension plans in Canada, and will describe the role of the trustee as a fiduciary, as well as outline the relationship between the union, the plan, and trustees. But before I introduce today's speakers, I do have a few technical housekeeping items for listeners. You should be able to hear me and see the PowerPoint presentations during the webinar. If you require assistance with your connection, please dial 1-855-352-9002. I'll repeat that number, 1-855-352-9002. Then press 1, wait for the prompt, press 1 again, wait for the prompt, and then press 1 again. This will bring you to a customer service agent who can help you connect. Following the presentation, we will open the floor to questions for the presenters. Questions can be submitted at any time by typing your question in the questions area of the control panel in front of you. At the end of the session, I will read any questions you have submitted for our presenters to answer. If for any reason we cannot answer your questions during this session, or we run out of time, please contact info@share.ca and we'll make sure your question gets answered. This webinar is scheduled for 1 hour, and I will now introduce our two guests. James Harnham is an associate in Koski-Minsky's Pension and Benefit Group and provides counsel to unions, employees, multi-employer pension plans, and trustees in all aspects of pension and benefits administration and litigation. A significant portion of James's practice involves assisting employees and unions with pension and employment issues that arise in corporate insolvencies. James has previously worked for the Court of Appeal for Ontario, the Workers' Action Centre, and Eco-Justice. In addition to James, we have Murray Gold, who is a senior partner in the pension and benefits practice at Koski-Minsky and is currently the firm's managing partners. Murray advises governing boards of public sector and jointly trustee pension and benefit plans across Canada. And he has led governance and financial restructurings of major public sector pension and benefit arrangements in Ontario, British Columbia, Newfoundland, and Alberta. He has a large profile in the country and is one of the most widely known lawyers in this field. Murray has long played an active role in the area of pension reform. In 2008, he was one of 4 expert advisors in the Ontario Expert Commission on Pensions and has since been committed to pension reform in regard to public sector and multi-employer pension plans. In 2014, Murray was appointed to Ontario's Technical Advisory Committee on Retirement Income Security, and in 2015 he was appointed as one of the 3 initial members of the Board of Directors of the Ontario Retirement Pension Plan Administration Corporation. Murray has a long-standing interest in climate change and its effect on the pension sector, and recently co-authored a report titled Climate Change and the Fiduciary Duties of Pension Fund Trustees in Canada. So with that, I will now turn this webinar over to Murray and James to do their presentation to you, which will last approximately 40 minutes, and then we'll go to questions.
Okay, well, thank you, Dennis. Thank you, Cher. This is Murray. we're here together, James and I, in our boardroom, and we will take chunks of this seminar and share them, go back and forth. The first chunk is mine. I'm going to briefly review our agenda for the day, and then take us through the first couple of topics. What we propose to do is an overview of the pension system in Canada, its key features, some of the issues that are arising in these days, in these times, and to review the legal structure, the legal regime under which they operate, to take a close look at some of the duties and responsibilities of pension plan administrators, and then at the end of the day, or the end of the session, to zero in on solvency funding, which is one of the more controversial issues today that is shaping the way that governments are regulating pension plans generally. So we start with the big picture, which in Canada involves the notorious three-pillar approach to retirement income security. The objective at the end of the day is that Canadians can retire in dignity, that they can retire with something that we've traditionally approximated as 70% of their pre-retirement income, so that they can continue to enjoy a decent standard of living in retirement. It's generally been viewed that 70% will allow you to continue with the quality of life that you had enjoyed prior to retirement. The assumption is at this point in your life, your children are gone, they've left the nest, they're independent, you're no longer supporting them, and other work-related expenses have also disappeared. So between pillars 1, 2, and 3, the system is designed to replace about 70% of your pre-retirement income. It does so in 3 pillars. Pillar 1 is the old age security, the guaranteed income supplement, and the allowance, together with minimum provincial minimum guaranteed income plans. These are pretty modest. Old age security is available to all residents. The guaranteed income supplement, as you know, is a means-tested amount to increase that basic payment where there are really no other sources of income. But as soon as you have other sources of income, the GIS, the guaranteed income supplement, is clawed back at 50 cents for every dollar of incremental income you have, and so it disappears reasonably quickly. Pillar 2 is the contributory public pension plan, the Canada Pension Plan. As we know, this is currently the subject of a lot of discussion. There are many attempts to try to improve it. Ontario has designed its own attempt to enhance the public system through the Ontario Retirement Pension Plan. In principle, the Canada Pension Plan, if you work through your entire adult life, and if you make the maximum amount that the CPP covers, which is the year's maximum pension earning, about 55,000, in principle, it's supposed to give you, when you retire, about 25% of that, so about $14,000. That's where it caps out today. And then on top of pillars 1 and pillar 2, we have pillar 3, and that's workplace pension plans, and that's really what we're talking about today. Now, pillar 3 workplace plans have a couple of key characteristics. In Canada, they are voluntary, meaning that there is no law that requires any employer or any workplace to provide a workplace pension plan. And that is why pillar 3 is not as extensive as it might otherwise be. Today in Canada, we estimate that about 1/3 of working Canadians are covered by workplace pension plans, and 2/3 are not. 2/3 have no workplace pension arrangement at all, and that is fundamentally rooted in the fact that workplace plans are voluntary. The places that we see them, the places that we see workplace pension plans concentrated are in unionized workplaces because they often flow from collective bargaining agreements. And we know that the public sector is particularly well unionized, and this is where we see the densest concentration of workplace pension coverage. In most provinces, in excess of 80 or even 90%, whereas in the private sector, it will vary by region, but we are in the probably no more than between 20 and 25% nationwide coverage in the private sector. Now, when we take one step down into the workplace pension arena, We recognize several different types of plans, and it's probably worthwhile focusing on their key characteristics, because as of, say, a couple of years ago, this new round of pension reform, what we're seeing in the legislation is a very specific kind of rulemaking that is targeted to each different kind of pension plan. So whereas Pension Benefits Act, when I started practicing many years ago, was kind of a thin document, it assumed all plans were defined benefit plans, was really quite weak even in regard to multi-employer plans, which were then not uncommon. Today what we're seeing is the evolution of pension benefit standards legislation that is much more detailed and that creates separate rules for different kinds of pension plans. Now the first kind that we'd be most familiar with in the public sector is the defined benefit plan. This is a plan that promises a specific monthly benefit on retirement. It's determined by a formula that refers to an employee's earnings, service, and sometimes age. Key to this kind of arrangement is that once a benefit is earned and accrued, it can't be reduced. You'll see that that's not true of all other arrangements, but it's true of this one, and this is what gives the defined benefit plan its edge. This is why people like it. It gives them a security and a predictability in a retirement income that other plans really can't deliver. Now, the flip side of the protection for accrued benefits is that funding deficiencies in pension plans have to be funded. So if at any point the assets in the pension plan aren't enough to deliver on that promise, on that formula promise, there's a deficiency, the employer has to increase contributions. Of course, employers don't like that, and that's one of the reasons that they're trying to exit the defined benefit business. All provinces have a terminal funding requirement, meaning that if a plan is wound up, an employer is obligated to fund any deficiency, any shortfall that exists at the time of wind up. And provinces also include in their pension benefits legislation deemed trust provisions, so that if the employer is in a CCAA proceeding, for example, there is a claim that can be made by the pension plan against the employer's assets in the event of a termination with a deficiency. In Ontario, we have as well, in the defined benefit space, Pension Benefits Guarantee Fund, and that is an insurance arrangement that is intended to guarantee the payment of pensions, but only up to $1,000 per month, where an employer has an underfunded plan and is insolvent and cannot top it up. Now, defined contribution plans are the traditional opposite of DB plans. All they are really is savings arrangements. Members contribute, employers contribute. The funds, of course, are invested. When it comes time to retire, that pool of money, the contributions plus investments, are either drawn down through a RIF or an annuity is purchased. We're beginning to look a lot more carefully at these arrangements because they're beginning to touch many more people. We see that they're not as efficient as defined benefit plans. We see that in that latter phase, which we call the decumulation phase, when we take that pot of money and convert it into a retirement income, there's a lot of inefficiency and there's a high level of cost to the arrangement. So there's a lot of attention being paid to that, not much being done. These markets are very dominated by only a small number of financial institutions, and so far there's not a lot of innovation. Hybrid plans are, as their name suggests, a mixture of DB and DC arrangements. They're quite common in the university sector and some other sectors. Typically they're structured to give you a DB formula pension as a minimum, but if the sum of your contributions, your employer's contributions, and investment earnings gives you a DC pot that can yield a higher income than your basic DB promise, then you get that higher income. These days, there's a lot of talk about target benefit plans. These are plans that do not make a firm commitment as to a future benefit. They make a target sort of a commitment, which means that there is a probability that the benefit in the plan will be paid. That probability should be a good, substantial possibility, but there's no guarantee. So that if you have a shortfall, in a target plan, there is no automatic funding mechanism. It is possible, if you're in a collective bargaining environment, to go back to a bargaining table, put more money into the pension plan and fix the deficiency. but there's no law that requires that to happen. So if there is a deficiency in the target plan, typically what will happen is that benefits will be reduced. The other kind of plan that many of the attendees today will be familiar with are jointly sponsored pension plans. These began to develop in the 1980s in the absence of a statutory framework. We now have in all our pension, not all of them, but in many of our pension benefits standards legislation, specific provisions that regulate JSPPs. These are defined benefit plans without a terminal funding requirement, so that if they are ever wound up with a deficiency, benefits are reduced. But so long as they're not wound up, they look and feel a lot like defined benefit plans in most jurisdictions. In some jurisdictions, however, new rules do allow for the reduction of accrued benefits on an ongoing basis in JSPPs. This is particularly the case in British Columbia and Alberta, where the regulator's consent is required for the reduction of benefits on an ongoing basis, but where it is possible. So that's a high-level summary of the basic types of plans that we're dealing with at the workplace level, and James will take us through the legal regime.
Thanks, Murray. So pension law is a very broad concept. It is made up not only of a variety of different legislation, but also common law rules. So judge-made law set through precedent over quite literally hundreds of years of judges making decisions. So when we start talking about what makes up the pension law regime, the first and most important is one that Murray's already touched on a little bit, and that's the provincial pension benefits standards legislation. So every province in Canada, other than Prince Edward Island, has pension benefit standards legislation. Prince Edward Island has actually tabled draft legislation at least 2 or 3 times, but it's never made its way through to being proclaimed. So ultimately, in Prince Edward Island, the issue of pension benefits legislation is almost dealt with through the common law. So it's kind of an interesting regime out there, although public sector pension law in Prince Edward Island is more advanced. So in addition to minimum standards legislation, which we'll talk a little bit about, the second most important piece of legislation that impacts pension plans is the Income Tax Act. We're going to talk about it, but the Income Tax Act generally allows for pension plans to have tax-favored status, both in terms of how they're invested and how they generate funds, but also in terms of how the contributions for employees and employers are taxed. So the Income Tax Act, in a sense, encourages pension plans. The concept of tax expenditures, which some of you may or may not be familiar with, but there's a lot of money spent by the government on allowing pension plans to operate, insofar as otherwise the contributions and amounts going would be taxed much more heavily. So it's a relatively expensive thing for the government, and the ITA, as a result, has very strict rules about the manner in which pension plans must be regulated. There's also a variety of other legislation that will impact at times: human rights law, employment standards legislation, labor legislation, family law, and succession law. So all of those things can impact at different times. And the fifth area is constitutional law, which at times has sort of key application in pension law, but often simply is not applicable. In Canada, unlike the United States, we have no constitutional protection for property. So when a public body tries to alter a pension plan through legislation, we don't necessarily have the same recourse to the Constitution that might happen in the United States. So constitutional law and pensions impacts in a variety of ways, but I think that often people will think that they can use the Constitution as something of a panacea to pension problems, and our experience has been that it's not always overly effective. So let's drill down a little bit more into each of these. Oh, and just quickly, Because pension legislation is provincial across the provinces, it falls under the heading of property and civil rights in the Constitution, so it's dealt with by the provinces. But of course, many of you will be familiar with plans that have members working in a number of provinces. And the basic rule is that employees working in a province are covered by the minimum standards legislation in that province. Broader rules about the plan, such as plan funding, are based on the legislation of the jurisdiction in which the plan is registered. There's something called an agreement respecting multi-jurisdictional pension plans, which has been agreed to by the pension regulators across the country. And it simplifies plan administration and eliminates the need for registration in more than one province. And the agreement delegates authority in matters relating to such multi-jurisdictional plans to the regulator of the province in which the plurality of members are located. But again, the substantive rules, the minimum standards in each jurisdiction continue to apply to the employees in that jurisdiction. So Murray is going to talk a little bit about provincial minimum standards and what the features of those are.
Okay, so as James mentioned, the provincial legislation and standards legislation sets the floor below which you cannot fall if you offer a voluntary workplace pension plan. The Income Tax Act sets a ceiling because these are tax-assisted arrangements. You can't provide benefits in excess of the ceiling. So the minimum standards, in addition to funding, which we've referenced, all plans need to be registered in Canada with a pension regulator. There are a set of rules governing fund investments. They're not particularly onerous or strict, but they do require that each plan administrator set out a statement of investment policies and principles, which is essentially an asset allocation. It requires that the plan administrator put their mind to the level of risk that they're prepared to accept in a pension portfolio and how they will allocate their assets in accordance with those risk standards, bearing in mind that some asset categories are much riskier than others, although they may offer higher returns for that risk. One of the controversial areas in regard to pension investments right now is the 30% rule. This is a rule that restricts pension funds from owning more than 30% of the voting shares of business corporations. And it dates from a time when pension funds were understood to be passive portfolio investors. They bought stocks, they bought bonds, they might buy some real estate, and if they didn't like what was going on, they would sell. Today we've really evolved well beyond that. Our largest funds have very significant holdings in private companies, and infrastructure projects, and illiquid investments that they can't simply turn around and sell if they don't like. And because of that, they want, with their illiquid investments, to exercise day-to-day control, just like any other business owner would want to do. They don't like being restricted by 30% limits on their voting shares, and so they have been lobbying to remove that limit. Practically speaking, the limit's already gone because pension funds can arrange their affairs to avoid the implications of the 30% rule, but there's now an attempt to remove it completely, which would ease the pension fund movement into alternative asset classes in which pension funds own up to 100% of infrastructure assets and or private business companies. Pension benefit standards legislation says that you can ask people to wait, but you can't ask them to wait indefinitely to join a pension plan. 2 years is more or less the limit. In Canada, there are special rules for people who are not full-time. If they have earnings or hours above certain thresholds, then they too have to be included in membership. All pension benefit standard legislation requires that there be a fixed retirement date. Not that people are required to retire on that date, but the plan's benefits must be structured around a normal retirement date. And they also require that all pension plans offer early retirement no later than 10 years prior to the early retirement date. Those early retirement benefits under statute law do not have to be subsidized. They can be actuarially reduced. Many public plans, they are subsidized. Vesting today, so once you're a member and you begin to contribute, vesting across Canada is now immediate. If you terminate your membership in a plan, all statutes provide for portability. They allow you to take the commuted value or, in some few instances, some other measure of your benefit and move it to an RRSP or to a successor pension plan. Those rights typically are good until age 55 and not always after that. Pensions must be in the form of joint survivor benefits. This is, again, based in the history of the workforce at the time these statutes were adopted, when working people often had non-working spouses, and so pensions were designed to protect them as well. There are spousal rights to pre-retirement death benefits set out in the legislation, and there are always regimes governing the wind-up of pension plans. In some provinces, not many, there is a rule that protects people who leave pensions before an early retirement date. It's called a grow-in rule, and it's best illustrated if with a plan, for example, that pays out an unreduced benefit with, say, 85 points. Age and service equals 85. If you are terminated from your job with 80 points, you're 2.5 years away from that unreduced benefit, but you may be only 55 years old, and you might have to wait until age 65 to get an unreduced benefit. With a grow-in, you can get that unreduced formula when you would otherwise have got it. In other words, 2.5 years after your termination. So it's quite a valuable right. It exists only in a couple of jurisdictions. I think we're back to James.
Yeah, thanks, Murray. So I'm going to talk a little bit about the Income Tax Act. So the Income Tax Act is the second major legislative regulator of pension plans. And as Murray mentioned, while the provincial legislation imposes minimum standards, the Income Tax Act, or ITA as I'll often call it, imposes maximum standards, largely in order to limit tax deferral. So as with provincial legislation, pension plans must register under the Income Tax Act and comply with certain ITA provisions in order to receive favorable tax treatment. Employer and employee plan contributions are deductible for the year in which they're made, but there are limits on the amount of such contributions. So if you are a member of a pension plan and also contributing to an RRSP, then your limit for your RRSP contribution room will shrink, and we'll talk a little bit about that in a minute. So as I said earlier, investment income is also given a favorable tax treatment, and there's also a small deduction available for pension income. Now, failure of a plan to comply with the ITA rules can result in revocation, although it's my understanding that typically a failure that is inadvertent will only be addressed on a going forward basis. So it's unlikely that the CRA would actually deregister a plan, as that would be quite a draconian result. So the Income Tax Act has established a very complicated system. We have at Koski-Minsky, we have 3 lawyers who specialize largely in tax, and Murray and I are not one of those people. So we have some knowledge, certainly more than most people, but it is a complicated area. So as I was saying earlier, RRSP room can be altered through pension adjustment. And so what that means basically is that a member's annual RRSP contribution is reduced by an amount to take account of the value of the member's accrued service in a defined benefit plan in a year. Or alternatively, the amount of the contributions made in a defined contribution plan. So that will alter your RSP contribution room on a dollar-for-dollar basis. There are also other sort of more complex ways in which this is implemented. So as some of you will be aware, it's often possible to purchase past service or to have an amendment to a pension plan which will alter the value of a previously accrued benefit. When that occurs, the CRA issues something called a past service pension adjustment, and that's additional pension credits should have been included in the member's pension adjustment in prior years, and so that'll reduce RSP contribution room for those years and going forward. And then there's also something that occurs called a pension adjustment reversal. And that happens when an individual terminates membership in a plan and receives a termination benefit that is less than the pension adjustment that had been calculated for them. So we see this frequently in the case of a large insolvency. So for example, in Nortel, a very large number of people had pension adjustment reversals, which gave them increased contribution room. The Income Tax Act also, although this is less of a problem than it used to be, and I suppose it's not really a problem, it's a good problem to have, but there is a maximum surplus that a defined benefit pension plan can hold. So any surplus above 25% of a plan's liabilities must be taken into account by an actuary in recommending what the contribution rate should be. And if ultimately the surplus amount is too high, the plan contributions from the employer to the plan will have to be suspended until it drops to an acceptable level. Although the days of surplus largely predate my role as a pension lawyer. So that's the Income Tax Act. Oh, and there's I've got a few other things on the PowerPoint here noting that there are issues of eligible contributions, pensionable service, and the relationship between employee and employer. So one of the key concepts in the Income Tax Act for the favorable tax treatment of pension plans is that contributions that are made to a pension plan must be based on pensionable service, which can only be, with some limited exceptions, for an employer, and pension earnings, pension contributions, have to be owing to a relationship between an employee and an employer. This is one of the issues that has arisen in relation to the Ontario Retirement Pension Plan that is being advanced by Kathleen Wynne's Liberal government, because currently, in order to register under the Income Tax Act, you can't have members that are self-employed. Of course, that's different than the Canada Pension Plan, which does allow for self-employed people to make contributions. So that issue is one that the Ontario government will need federal assistance with in order to allow that plan to work. Okay, so we've talked a little bit about minimum standards legislation. We've talked about income tax. The next thing we want to talk about is the concept of fiduciary responsibility. Fiduciary obligations have their origin in the common law, but they also are reflected in pension legislation across the country. So judges, when writing about this issue, will frequently say, you know, a pension plan administrator has a fiduciary duty that arises both under the statute and at common law. The premise is that a fiduciary relationship arises in circumstances of vulnerability. The fiduciary must set aside their own interests and act exclusively in the interests of another person. Nothing may be done which is not directed solely towards the best interests of the trust beneficiary or beneficiaries. So it's a very onerous obligation. It's one that we see in pension law, and there are certainly other situations where it arises. It will arise in the lawyer-client relationship. It will arise in other categories depending on whether or not this sort of special vulnerability exists. So when we talk about the content of fiduciary duty, we're typically talking about it for an administrator, and of course in multi-employer plans, the administrator will often be a board of trustees. And so when you're dealing with fiduciary duty questions, you always have to be very cognizant of what your role is when you're acting in a certain role. So for example, a union official who has a role as on a union and also one on a board of trustees will have very different roles in each one. And when serving as a trustee, must make sure that they are acting in the interests of the beneficiaries and not only in the interests of the union, or conversely, if it's an employer representative on a board of trustees, they can't be acting in the best interests of the employer. Of course, the interesting thing here is that we have created a system in Canada of multi-employer plans and jointly sponsored plans, which in a sense create a substitute for bargaining at the level of the trustee table, where decisions are being made through negotiation at the level of the trustees. And so trying to separate out the proper role as trustee versus the role of advocate for the organization that appointed you is certainly a difficult one, and one that we're consulted on frequently. So as I was saying, the common law creates obligations, but the statute also creates obligations. So across the country, you will see legislative provisions that deal with standards of care and with avoiding conflicts of interest and with other parts of the fiduciary relationship. So we've just put on the PowerPoint a few examples. So in the British Columbia Pension Benefit Standards Act, the rule on conflict of interest is that an administrator or board of trustees that is the administrator must not knowingly permit their interests to conflict with the administrator's duties and powers in respect of the pension plan. So that's that conflict we were just talking about, and each legislation in the country has a similar provision. There will also typically be provisions dealing with the standard of care that an administrator must have. Now this is part of the fiduciary duty, but it's also a broader standard of care that could be assessed both on the legislative side and in the common law. If you breach your standard of care, you can be found liable for negligence. So in Alberta, the statute states that the administrator must exercise the care, diligence, and skill that a person of ordinary prudence would exercise when dealing with the property of another person. You'll see in Nova Scotia, basically the exact same provision is repeated, and across the country you'll see really the same content of the standard of care for an administrator. When you're seeking to meet the standard of care, it's not a standard of perfection, and it's normally one that is assessed on the basis of procedure. So you need to make sure that you are doing the things that a prudent person would do when dealing with the property of another. So that can include acquainting yourself with the terms of the trust, ensuring that the investments of the trust fund are properly supervised and are performing well, seeking professional advice when appropriate, and of course this is an extremely important part of any kind of administrator or board that is not made up of purely of experts, as when, say, when Nortel administers their pension plan, they are not in the business of running pension plans. They're in the telecommunications business, or they were. And so they need to hire the right people who can give them the right advice and know how to deal with this. So as part of the administrative responsibility, it would also be necessary to bring proceedings to protect and or defend the trust property when necessary. There's also a duty to communicate openly and honestly and provide all the knowledge and information to members of a plan such that they are able to be total participants. They know what to expect. They know what their duties are, what their obligations are, and what their entitlements are. And that duty to explain, again, both arises from the statute and from the common law. And then, of course, where the trust is in jeopardy or there is a real concern that employees, pension plan members, might not receive the pension they've been promised, open and frank communications with the beneficiaries is important and part of the content of this duty.
Okay, so it's we thought we would spend a little bit of time talking about solvency funding because it's really beginning to control a lot of the directions in pension reform. So solvency funding was introduced in the 80s in most jurisdictions at a time when it didn't matter very much. It was introduced in order that if a pension plan were wound up, it would have enough assets to satisfy its liability. There was a theory that that is really the proper benchmark for pension benefit security. As long as the plan's ongoing and there's no wind-up, it doesn't matter quite as much whether the pension plan is fully funded, but it does matter if the pension plan, if the employer becomes insolvent, the pension plan becomes wound up. So what happens in a wind-up is that the employer ceases to exist, the pension plan ceases to exist, and all the obligations of the pension fund are transformed into one of two types. Either members, especially retirees, receive annuities from insurance companies that continue to provide them with the pensions that they had earned, or if they're younger members, they will receive a lump sum amount, a commuted value, that reflects the value of their pension entitlement. In both cases, the price of annuity and the price of a commuted value, the amount of a commuted value, depends on current interest rates, the interest rates on 10-year Government of Canada bonds. And the lower the interest rates are, the higher the value or the cost of the pension. If interest rates are very high, then annuity prices are low. If interest rates are very low, annuity prices are very high. So when solvency funding was introduced in the 80s, interest rates were high. Solvency funding didn't really bite. It didn't matter very much. The going concern funding is what dominated. But of course, today interest rates are very low. Solvency costs are much higher than going concern costs, and so solvency is driving pension funding in this environment, and it's a very expensive form of funding, which has got a lot of people very concerned. Employers don't want to pay these higher costs, and employees are finding that if the plans require funding on a solvency basis, employers are coming to a bargaining table and saying, we can't afford it, we need to convert the plan, terminate the defined benefit character of it, turn it into a DC plan, or reduce benefits, reduce the amount of the liability. So, we've reached a point where some people will look at solvency funding as the true benchmark for benefit security, and many in our firm do that. Giving up solvency funding does mean a lower level of benefit protection. On the other hand, there are circumstances in which preserving solvency funding puts the plan in an impossible position because the employer won't sustain it at that level. So we've seen three avenues for change. One, after the financial crisis, government said, well, interest rates are very low, we think that's going to be temporary, we're going to give you temporary relief, and most jurisdictions have some form of temporary relief. But it's been 8 years since we came out of the financial crisis, 7 or 8 years. It's no longer the consensus that interest rates are low only temporarily. There is an emerging view that interest rates will be low for a long time. And so the temporary solution is now receding in the regulatory mind as an appropriate route. And there are two other possibilities that governments are pursuing. One is a completely different funding regime that is somewhere between going concern and solvency funding. We've seen this in Quebec, but only Quebec so far. And the third alternative to solvency funding is the conversion of a defined benefit plan to a target plan. In other words, eliminating the guarantee that attaches to defined benefits, creating a target promise instead, and some regulators and governments have said, look, if you don't want to fund a defined benefit promise on a solvency basis, then you need to walk away from the defined benefit promise, substitute a target promise, and then you will be relieved of solvency funding. So these are not altogether pleasant choices for people, but these are the routes that we're seeing develop in Canada. We thought we'd spend a few minutes on target benefit plans because their target benefits are making their ways into defined benefit plans. You can have a plan that has multiple different types of benefits. It can have defined benefits, target benefits, and DC benefits. And we're seeing more target benefits, especially in regard to indexation in all manner of plans. When you have a target benefit, you need to get some sense of how likely it is that it's going to be paid. What you don't want is you don't want a regime that says to people, yes, you're going to get this benefit, it's only a target, but don't worry, you're going to get it, when you should really know that the chance of delivering that benefit is not very good. Somehow, if you're going to make a promise for a target benefit, there needs to be some high level of security that that target will in fact be achieved. And that's where the new funding rules for target benefit plans come in. But at the same time, target benefits are target benefits. They can be reduced. They're not guaranteed. And any target benefit plan administrator must have the authority to reduce benefits. That authority can be purely discretionary. In some jurisdictions, the administrator gets to choose which benefits get adjusted, or sometimes the sponsors get to choose that. In other cases, New Brunswick, for example, it's highly prescriptive. Legislation will tell you which benefits get reduced and in what order. The most developed target benefit funding rules are in the West, in British Columbia and Alberta. They're designed to deliver a level of certainty that is this. They're designed to deliver an 85% chance that the benefits that a target plan promises will not be reduced in the following 3 years. Now this is all based on modeling, it's all based on actuarial modeling. You can't take that 85% figure completely literally, but it provides a basis for designing a funding regime. And basically what they do in the West is they require that you fund your normal costs, so your current service costs, just like happens today in any defined benefit plan. And then on top of that, that you create a reserve, which is called a provision for adverse deviation. And the approach out West is to say, look, the riskier your plan is, the higher your PFAD or provision for adverse deviation needs to be. If you're very conservatively invested and you use a very conservative interest rate in your actual evaluation, then you can get by with a relatively modest PFAD. But if you have a lot of money in risky equities in your portfolio and you're using a very aggressive discount rate, then you're going to need a larger PFAD. So there are formulae in both the BC and Alberta legislation, and frankly Quebec is similar, that define how you calculate a PFAD and what the funding rules for target benefits are. So I know we're pressing on time and we want to leave time for questions, so I don't think I'm going to spend much time on the last slides here. I think perhaps we can just go to questions.
Thank you, Murray, and thank you, James. That was very good. We have some question activity, and I'm going to take the first one from, I believe it's Christine, and she is inquiring about the bankruptcy protection provisions for employers that have a DB plan underwater. And specifically, what can plan members do in those circumstances? And is it consistent across the country in terms of activity?
So I have to say it's a major part of my daily life, and I wish I could say that this had a simple or an obvious answer. I think it's important to note that when we talk about bankruptcy protection, it's a fairly broad term, and we have a couple of different procedures in Canada that can be followed by an employer when they go insolvent. So in a traditional bankruptcy under the Bankruptcy and Insolvency Act, an employer is assigned into bankruptcy. It assigns itself into bankruptcy as a result of not being able to pay its debts, or sometimes a creditor will assign it into bankruptcy. When that occurs, all the employees in the workplace are terminated. Provincial regulators will typically at that point order a pension plan to be wound up if it had not already been wound up. And then the wind-up process goes ahead, the bankruptcy process goes ahead, which is typically about selling any realizable assets and having money paid into the estate. And the pension plan is itself a creditor. So the plan administrator, who will frequently at this point have been appointed because the employer is no longer operating. So you'll get an actuarial firm appointed. They then become the wind-up administrator and seek to have money come into the plan. So in a traditional bankruptcy, there are very few protections for pension plans. Each of the provincial pension benefits legislation across the country contains provisions which seek to put the pension plan and its members ahead of other creditors. This is typically done through a mechanism called a deemed trust. Basically, where something is held in trust, that doesn't count as the estate of the bankrupt, so it should go to the person or persons that it's held in trust for. Unfortunately, case law from the Supreme Court of Canada, starting in about the 1970s, has held that these provincial deemed trust provisions are unenforceable in the bankruptcy when a proceeding is commenced under the Bankruptcy Act. So that means that really pension plans simply go to the same point in the line as any other unsecured creditor. There's a limited exception to that, and that's in section 81.4 and 81.6 of the Bankruptcy Act, which basically finds that anything owing for normal service costs have to be paid in priority. Under the CCAA, which is the Companies Creditors Arrangement Act, and is a restructuring statute which is increasingly being used to liquidate companies, the status of the deemed trust is much more up in the air. There was a decision from the Supreme Court a few years ago called Indelex, which dealt with the deemed trust to a certain extent, but the extent to which it can be used in a CCAA proceeding is still an open question. So in terms of what pension plan members can do, often not a lot, unfortunately, really often not a lot. In the CCAA, there are important steps that can be taken to protect rights, and at that point I think that the unions will need to probably to get counsel to help deal with it, because it is a very complex and emerging area. And yeah, so that's a long-winded answer to that question.
And let me just add this. I mean, much depends on whether you have a collective agreement and whether there's going to be a purchaser of the company. So if the company is being liquidated, as James says, you don't have a ton of bargaining power. It's a purely legal process in which you assert your claims and other people assert their claims, and you try to raise your claim on the ladder. But if your company is being purchased by a new buyer and there's a collective agreement in place, then a trade union does have some clout. And we've seen this in the Canada insolvencies in the early 2000s, and the Stelco insolvencies, Steel insolvencies since then. It's a very different game because the collective agreement is protected to a significant degree, and as the bargaining agent for the employees, you've got clout to bring to bear on pension and other matters. So much depends. There's a lot more you can do in a unionized workplace where there is a buyer of the business than in a liquidation.
Okay, well, thank you. That's a very thorough answer, and hopefully that's some help to Corinne. The next questioner or question is from Peter, Peter Smith perhaps. He is asking, can unions control the decisions made by trustees they appoint?
Well, that's always a testy question. They cannot control them in the following sense, that once a person is appointed as a trustee, their obligation as a trustee is, as James described, to be a fiduciary vis-a-vis the trust. In other words, to act in the best interests of the trust, to do so in good faith and to the best of their abilities. That's the obligation of every trustee. So to the extent that a union appoints a person and then directs them in a way that the person feels is contrary to their fiduciary obligation, the person is not legally permitted to act on those directions. The person must, at all times, act in the best interests of the plan and its members. Now, the reason that we have boards in this country that are representative boards by and large, as opposed to independent expertise-laden boards, is because we collectively have come to view come to understand the significance, the importance of having member representatives and employer representatives sit on boards and bring the perspective of the trade union and the employer to the pension table. And there's nothing wrong with coming from that background. There's nothing wrong with being sensitive to the interests of the trade union or the employer, the labor relations aspects to these decisions. In fact, that's, I think, what's contemplated with representative boards, that they do have that understanding. But they can't take that understanding sort of the next step and simply act on direction from the trade union. They must act at all times in the best interests of the plan and its members.
Okay, thank you. The last question we'll take today is from Heather. She's inquiring as to whether hybrid plans are subject to solvency requirements as well.
Well, they are, to the extent that they provide a defined benefit. They are required to fund the defined benefit in the same way as any other defined benefit. So typically with a hybrid plan, the deal is that the defined benefit is lower than you might find in a pure defined benefit plan. But the flip side of that is that the member also has the opportunity to get a better benefit if the DC side of the benefit equation is superior. So the solvency funding may be a little less onerous, but it still applies in the case of a hybrid plan.
Okay,
I guess the only thing I might quickly is that hybrid plans are common in the university sector. They're not that common otherwise, and in some jurisdictions, the university sectors are exempt from solvency funding. In other jurisdictions, they're not. So it's not only a question of how hybrid plans are treated, it's a question of how sectoral plans are treated. So you may have a hybrid plan that is also in a solvency exempt sector in some provinces and therefore not subject to solvency funding, not because it's hybrid, but because it's in the sector.
Okay, thank you, Marie, and thank you, James. I'd like to also thank all of our participants here today. That was an hour that went by extremely fast, in my opinion. If you have any questions or comments about today's webinar, and hopefully you will, you can please email them at info@share.ca. Our next webinar in this series focuses on capital stewardship and will examine the growing role of social, environmental, and governance factors in pension plan investments. If you would like to attend or find out more information, please visit www.share.ca/NUPGE-webinars to register. I want to thank again Murray and James, and to Share for helping to organize these webinars, and thank our participants, and hope to see you at the next webinar next week, I believe it is. Thank you very much to everybody involved, and enjoy your afternoon.
Thank you.
Thank you.